introduce our moderator, Shalom Stone from Stone Conway. Shalom has been such a great friend to the New Jersey Civil Justice Institute. There's a background on him. He has tremendous experience in state and federal courts, argued numerous appeals before the New Jersey Supreme Court and the Third Circuit. In 2007, was nominated by George W. Bush to the Third Circuit Court of Appeals for the seat that now Justice Alito had vacated. The loss to the Third Circuit, but New Jersey is just so very happy to still have him laboring here with us. Shalom has authored 2 previous amicus briefs for the New Jersey Civil Justice Institute, including one victory that we had in a case involving rescission of fraudulently procured med-mal policies, and most recently, it was a case involving one of our members where Shalom was defending the workers' comp model as applied in the context of third-party contractors. Really important case that's actually pending right now, and we will be anticipating a decision in that case shortly. But Shalom has also moderated previous panels for us, has done a great job, and we appreciate all his work as well. And I will let Shalom proceed.
So we're here to talk about jurisdiction. Chris talked a little bit about the implications of BMS this morning. We're going to be talking both about general jurisdiction and specific jurisdiction. So let's start with a quick overview of where the Supreme Court is these days. We're going to go back to the 2014 case, Daimler AG versus Baumann, an 8-1 decision issued by Justice Ginsburg with a concurring opinion, more of a dissent of sorts, by Justice Sotomayor, who is the gadfly on these issues. So the Daimler opinion begins with the Goodyear decision, which itself goes back to 2001, which sets up this paradigm for general jurisdiction. The paradigm is a corporation is fairly regarded as home in its place of incorporation and its principal place of business. And Daimler takes that concept and essentially, but without actually saying so, creates the new paradigm, which is that the place of incorporation and the principal place of business are the home, and almost a de facto presumption that that's just about it, except for really odd situations. Odd situations are described to some extent in the footnote 19 of the Daimler opinion that says, in an exceptional case, a corporation's operations may be so substantial so as to render the corporation at home outside of the state of incorporation and its principal place of business. And one of the issues that the court needs to confront and sort of tangentially addresses in the Bristol-Myers decision is there really such a thing as an exceptional case where their corporate presence is so substantial that we're going to acknowledge and allow general jurisdiction? So that brings us to this past June's decision in Bristol-Myers Squibb, another 8-1 decision, this time authored by Justice Alito, and a dissent from Justice Sotomayor. Bristol-Myers Squibb was sued in California regarding Plavix, a blood thinner, and the plaintiffs we put in 2 groups. We've got 86 California residents. Purposes of the opinion, we're going to assume that these 86 California residents have been harmed in California, and 592 from 33 other states. And the question, of course, is whether those 592 plaintiffs are going to be allowed to sue Bristol-Myers in California as non-resident plaintiffs. So Bristol-Myers is incorporated in Delaware. It has its headquarters in New York, and according to the court has quote-unquote substantial operations in New York and New Jersey. The Bristol-Myers presence in California includes 5 research and laboratory facilities, 160 employees, 250 sales reps, and of course it sells Plavix in California. Interestingly, general jurisdiction was not an issue before the Supreme Court. It had been addressed below, so the Supreme Court doesn't get into it and specifically disavows the general jurisdiction aspects of the case. It deals solely with specific jurisdiction, which requires a connection between the forum and the underlying circumstances of the case, the underlying controversy. And it says that, the court says that the defendant's general connections with the state are not relevant. In other words, it rejects the California Supreme Court's decision to sort of meld general jurisdiction and specific jurisdiction. The court says, no, those are two completely separate things. And Bristol-Myers' general presence in California isn't relevant to the specific jurisdiction dispute. Claims by other plaintiffs who are California residents and therefore do have specific jurisdiction, that's also not relevant. Bristol-Myers' contract with McKesson, a California company, to distribute Plavix nationally is not sufficient to create specific jurisdiction either. And then the court has a brief discussion about what do we do with this, where we have plaintiffs from all over the country and want to sue in one place at one time. What are we going to do? The court says, well, the solution's simple. You can sue Bristol-Myers Squibb where there is the paradigm of general jurisdiction. That is to say, where its principal place of business is or where it is incorporated, i.e. New York and Delaware. Due process clause imposes the same restrictions on a federal court that it is imposing on the state courts in California, for example, is not being decided today. And the last issue that I want to make about BMS is it does not decide where any plaintiffs could sue a foreign corporation. And that's one of the issues that the court's going to have to address, and hopefully we'll talk a little bit about that today. With that as the backdrop, I'm going to introduce our panelists who are going to be addressing these issues from their various professional perspectives. For our first speaker today is Sean Murata. Sean is a senior associate in the Appellate and Supreme Court Practice Group at Hogan Lovells in Washington, D.C. Sean was the lead associate in the BMS case, which was argued by Neil Katyal, his former boss, as the acting Solicitor General. And Sean is also a national personal jurisdiction counsel for a major automotive manufacturer. Sean is going to talk today about some behind-the-scenes perspectives on the BMS decision, and he will talk also about BMS and related decisions and how they're playing out on the ground, both in pending cases and in future cases. Our second speaker is John Kim, who is Assistant General Counsel in-house at Johnson & Johnson and heads J&J's Product Liability Litigation Group. John has significant experience in product liability litigation, securities, and other high-stakes commercial litigation. John will share his in-house perspective on these important jurisdictional issues, and we'll also talk about whether the Supreme Court's decisions will change how companies operate, how they interact with their corporate contracting practices, and where companies are going to be sued. Ted Frank is the founder and director of the Center for Class Action Fairness. He has significant appellate experience, but he is best known, as the New York Times put it, as the leading critic of abusive class action settlements. Abusive meaning the money goes to the lawyers and not to the plaintiffs. Is that a fair characterization? Fair characterization. Ted's going to talk about some of the policy issues because he's clearly the smartest person on this panel, and talk about things like forum shopping, tort reform, and the impact that these decisions will have, or perhaps won't have, on corporate decision-making in the real world, because we all know that corporations are real people. And our last speaker is Eric Hassel, my good friend and a partner with Spiro Harrison. Eric has extensive experience in a wide variety of litigation and complex litigation matters. He's a former federal prosecutor, a former DOJ official, was intimately involved in the Whitewater investigation, and as Alita mentioned, has a fair amount of experience representing plaintiffs, especially in large qui tam matters, and Eric will share all of his above-referenced perspectives on how these decisions will impact all of the participants. So with that said, I'm going to turn the floor over to Sean.
Thanks so much. So as mentioned, I worked on the Bristol-Myers decision, so I'll talk a little, and we just gave the background on Bristol-Myers, so let me talk about where we are before Bristol-Myers and where we are now after Bristol. Requires three things. You have to purposefully avail yourself of the privilege of doing business in the forum. The plaintiff's claims have to arise out of or relate to those contacts that you have with the forum. and essentially jurisdiction has to be fair. And the question was, what did this arise out of or relate to thing mean? Because the Supreme Court created the standard in 1980, then said it wasn't going to tell you what it meant by that standard, and whether arise out of and relate to mean two different things. And so it's been an open question since then, and courts had split essentially three ways on the question. I would say the vast majority of courts that have addressed the question head on have said that it's a but-for standard. So in other words, you have to ask yourself the counterfactual, assume the defendant had no contacts in the state whatsoever. Would the plaintiff's claim still occur? And if the answer is no, then there's no specific jurisdiction. Some courts have said, okay, but-for is a pretty good start, but there has to be something more than that. It has to be proximate cause, because if you have just a but-for standard, you can find the most random contact that might have some relationship to the case, and that will allow specific jurisdiction. So to take an example we gave in Bristol-Myers Squibb in our brief when we were advocating for a proximate cause standard, suppose the scientist from Bayer goes out to a conference in California, here's a speaker, and that's the aha moment for the drug. Then everybody can bring their lawsuit in California. That's pretty fortuitous. That shouldn't be, even though it is in the but-for chain of causation, in the sense that if he hadn't gone to the conference, he wouldn't have the aha moment, the drug would have been created. You shouldn't have that. That should not lead to specific jurisdiction. And then the third approach is some sort of non-causative approach, which itself has all sorts of different formulations, ranging from Texas, which has I would say a fairly defendant-friendly substantial relationship test, to Washington, D.C., which allowed a slip and fall in Virginia at a supermarket to go forward in D.C. because the grocery store also advertised in D.C. So that's the three-way split. The court took the case in 1990, a case called Carnival Cruises, which you might remember from law school as the venue clause that was on the back of the ticket. And that case was also supposed to decide this arise out of a related to question, but because of the venue choice provision, they never got to it. So we came to the court and said, hey, this split has been hanging out there for 2 decades. You really should address it. And the court took the case, and we really thought we'd have a chance to get a clear standard for what arise out of a relate to means. And sure enough, the court punts yet again. The Bristol-Myers Squibb decision, as good as it is, does not actually give you a clean test for what arise out of a relate to means. You can sort of cobble together some language in it and maybe draw some inferences that it's rejecting the non-causative standards, or at least the very loose non-causative standards. But beyond that, you don't really know. So the split lingers, and I think it's going to be a big question going forward. How that continues, how that deepens, whether some courts on different sides of the split reassess themselves in the wake of Bristol-Myers Squibb, which might not be a good thing. So we're going to have to see how that all shakes out. I think that's the big takeaway from Bristol-Myers Squibb, that split is still out there.
Do you think that the outcome is going to necessarily be some form of causation?
I think so, and I think this is the big takeaway I want to lay out, which is stream of commerce. Stream of commerce, which is hugely important in products cases, which is what, the classic stream of commerce case is a car is shipped into the United States, let's say from Germany, to a distributor. Distributor gives it to a car dealership, guy buys it, drives out to Oklahoma, and the car explodes. That's worldwide Volkswagen. And in worldwide Volkswagen, there was no jurisdiction because the only defendants were the car dealers back in New York where the car was purchased. And they said, well, the car dealers in New York didn't do anything. But then there's this weird paragraph in worldwide Volkswagen where they say, Audi and Volkswagen, even though they had not contested personal jurisdiction, they would be subject to jurisdiction here because, they do business in Oklahoma, and it's not really clear what the analysis is after that. And what's troubling, I think, is that there are certain readings of worldwide Volkswagen that are inconsistent with the but-for test. Because, and I deal with this case all the time, the car wasn't built there, wasn't sold there, all the people did was drive through Oklahoma. And so if you think that line of dicta in worldwide Volkswagen is right, it challenges the but-for test. And I think that's going to be the but-for test's biggest challenge moving forward.
Am I right? Did the Supreme Court just deny cert on a case that could have also addressed this very issue?
Yeah, so this is good. We didn't even coordinate in advance, and everybody's teeing up my points. And yes, so there was the MM case from Illinois, which involved one of the antidepressant drugs. And one of the things you're gonna see is that the plaintiff's bar is gonna go out and say like, all right, it's a but-for test. We'll find something in our favorite state that is somehow related to your product. So what we're seeing in the pharmaceutical area is study sites. Because study sites are all across the nation. You probably did at least one trial somewhere in the state. And what plaintiffs will say is, look, that study site information went into your development of the drug, but for, at least in part, that study trial, you allegedly would have, given the warnings, I suppose, that should have been given, or the drug would have been better done. They don't have any proof that that would happen, but they would say, look, it at least contributes to the overall warnings. And therefore, I can bring all my lawsuits in Illinois, which is what I wanted to do anyway.
Are you likely to then see a lot of discovery related to this, to the jurisdictional issue, where they put out a claim and say there's some but-for relationship to this state, and then when you file your motion to dismiss, they say, well, we want discovery so we can find that hook?
Oh, absolutely. And I work, as I mentioned, I do work for a major auto manufacturer, and I think they often use this discovery as a bludgeon, because they say, look, do you want to slog it out and get this discovery, and we're going to get in a discovery fight, and you don't want to produce it, if you just withdraw your motion. And thankfully, I think some defendants have been brave enough to step up and say, we'll do the work, and we'll interpose our objections, and we'll go to the mat on them because we don't want to be intimidated by it. But yeah, certainly plaintiffs can churn out 10, 15 pages of document requests that will make it hard for you to stand on your personal jurisdiction motion. So yeah, I was arguing a personal jurisdiction motion in the Philadelphia Court of Common Pleas in a benzene case on Wednesday, where plaintiff's counsel got up and said, there was a supplier in the state of Pennsylvania, and they submitted a material data safety sheet that must have been used to create the warnings, and therefore all my cases can stay in Pennsylvania. They're going to start looking up and down the chain and look for any connection in the state that they can say have a but-for relationship, which is why getting to proximate cause is going to be so important. But Bristol-Myers Squibb,
let's talk about that idea. Doesn't the Supreme Court's discussion in BMS about McKesson really do away with that idea? Because the Supreme Court says the fact that BMS has a contract with McKesson to sell products nationally, McKesson is in California, wouldn't that have been enough to satisfy what cause standard?
Well, it wouldn't have been, because the plaintiffs conceded in that case that they can't trace any particular Plavix pill, although they probably could have through batch numbers and others if they had tried hard enough. They just didn't want to. So, in the McKesson case, probably the problem was they couldn't show that any of their pills came from McKesson. If they could, we might have actually had a harder case. But now that's what they're going to start trying to do. And that's why I think, again, getting the proximate cause is important, because maybe you could show that the pills sat in a warehouse in California for 5 days before they were shipped to Texas, where you took them. I guess that's part of the but-for chain, but it shouldn't be enough for personal jurisdiction. And these are the kinds of questions we're going to be seeing.
So I would disagree. We have argued, and we will argue, that the McKesson issue of BMS takes care of a lot of this. And so we have taken that position. Whether courts are going to listen to it, it's a whole different issue, but we've taken the position that the McKesson discussion takes care of a lot of this.
Have you had any results from those McKesson-type arguments?
No, but I can talk. Let's finish off.
Yeah, sure. We'll let you go.
Yeah, I can talk about it.
But I think part of the problem, but I think what we're getting from this discussion is, when Bristol-Myers Squibb came out, there was a big rush from the defense bar to say that Bristol-Myers Squibb now answers every question anybody has ever had about personal jurisdiction, and is going to show that, plaintiffs' counsel have no chance anymore. I don't think that's right. I think they are very industrious. I think they are very creative, and they're going to start pushing at, some of the questions that Bristol-Myers Squibb leaves open, and we're going to go back through this whole cycle again in the Supreme Court once more. Another hot issue in personal jurisdiction after Bristol-Myers Squibb, which isn't necessarily Bristol-Myers Squibb, but it's consent by registration. There were cases from the 1920s that held that if a state allowed it, if you registered in a state to do business as a condition of doing business there, that could be construed as consent to general jurisdiction, which is to say consent to all suits of any kind in the state. And that has been a hot area for plaintiffs' bar as the old general jurisdiction standard goes away and they can't find specific jurisdiction. There's been tremendous success on this in the statutory area, given that the New Jersey Appellate Division, the Wisconsin State Supreme Court, Oregon State Supreme Court, Missouri State Supreme Court, Illinois State Supreme Court have all held as statutory matters that their registration statutes do not create consent by registration. So that has been a tremendous success, but we've got a long way to go. Pennsylvania has a statute that explicitly imposes general jurisdiction as a condition of doing business. So it's going to have to be a constitutional fight there, which is going to be harder, I think. And I'm currently litigating a case in Minnesota which has an old decision from 1990 that says consent by registration is the law in the state, and we're going to have to get them to try to flip it in light of this new case law. So, and New York is also doing that fight right now as well. So it's going to be a big issue, and we'll see how it plays out. But trends are so far pretty good. Last thing I want to talk about is what Bristol-Myers Squibb has means for nationwide class actions. The rule from Bristol-Myers Squibb quite clearly is that every plaintiff has to show over every defendant that there is personal jurisdiction in the forum state. So, it's not just one plaintiff and it's not just one defendant can support a mass action. The question in class actions is, do you treat the absent class members as plaintiffs for purposes of this rule? And do they have to be before or after certification, and all those sorts of questions? The court has said in some contexts the absent plaintiffs are parties to the case. The court has said in other contexts that the absent class members are not parties to the case. So for instance, the absent class members are not parties to the case for diversity jurisdiction. They are parties to the case for, as you know, Ted, at least the question is being able to appeal an adverse settlement. They don't have to intervene first. So that's going to be an interesting question. It's unclear whether those sorts of statutory distinctions make a difference in the due process context. We're certainly arguing they're not. And if we're right, that's going to essentially close down the nationwide class action outside of the general jurisdiction states, or outside of a state where conduct relevant to the entire class's claims occurred. So you can't just find one class representative in your favorite forum state and then have a whole nationwide class come in. And Justice Sotomayor raised that in her dissent as one of the possibilities in the future, and I think there are any number of defense counsel who hope she's right, that the decision does mean that. But we're going to have to see how that plays out.
What about federal court?
So federal court's the interesting question. The Supreme Court has consistently bracketed the question of whether the 14th Amendment constricts federal courts the way it does state courts.
Or more precisely, the Fifth Amendment.
Yeah, I think that's actually the key distinction, because the 14th Amendment says that it's contacts with your state, and that generally applies in federal court through Federal Rule of Civil Procedure 4K. The court has never decided whether the Fifth Amendment means that you can take it up a level of generality such that Congress can, by statute, create essentially nationwide jurisdiction, that if you have minimum contacts with the U.S. as a whole, you can be sued in any of its district courts. Most circuit courts have held that's the case, and I think it's kind of hard to question the logic of it, given that they're two separate sovereigns. There are good reasons for Rule 4K, so you don't have vertical forum shopping, but it actually helps when you're making policy arguments about this stuff to say, look, if Congress wanted to create a nationwide forum for this stuff, it could. You just have to go talk to Congress about it. So that's actually a good way when you're talking at the state level or when dealing with state cases to say that if you're worried about fractured cases or cases having to go everywhere or nobody can sue in the same place, it's really an issue for Congress because Congress can maybe do something about it.
Thank you, Sean. John, the floor is yours.
Thank you. Hi. So whenever they ask a corporate guy up here, it means you really want to get into like the nitty-gritty of the law. Tell us what you really think about the gut thing. This is like the cousin Vinny, what do you really think? What's the impact here for corporations? So, for us, for J&J, people may have been, if anyone's following the talc saga, that this week we actually got probably one of the most impactful decisions arising out of the BMS decision. And that's in our talc case in Missouri. Just to give you a little background on that, that case is comprised of 63 plaintiffs from jurisdictions all over the country and 2 from Missouri, one actually from St. Louis, one from St. Louis County, which becomes important in another issue. But so this is a case where, all these plaintiffs, because of lax joinder rules, get to piggyback on the Missouri residents. And when the case was filed, of course, we objected to personal jurisdiction issues, and the court really ruled at the time that it has jurisdiction because of pendant party jurisdiction, which, again, it's the last time you'll hear that, because that disappears. But their theory, the court's theory was, we certainly have jurisdiction over the Missouri residents, and the other plaintiffs who have no relationship to the Missouri residents, never met the Missouri residents, and only by fortuity happen to have the same lawyers, get to piggyback on that jurisdiction of the court. So we objected that right away. So what the court does is, instead of, in order to try these cases, they sever off some of the plaintiffs to try, at first, on an individual basis. So the appeal arises out of one of the cases that was severed off, and that's Jacqueline Fox. Jacqueline Fox was actually a resident, I want to say, of Tennessee. So you have a Tennessee resident suing a New Jersey corporation in a state court in Missouri, right? Doesn't make a lot of sense. Didn't make a lot of sense to us. But we tried to get the judge to hold off. We actually told the judge at the time, hey, there's this case that's going up through the ranks. And boy, it would be a real waste of time for us to spend all this time and effort trying our case when, the U.S. Supreme Court might rule on a case that's very similar and put this issue to bed. The court declined to take us up on that offer and tried the case to a $72 million verdict. Don't ask me about the merits of the case. I could go on. I've seen me go off on hours telling you about the merits of the Tao cases, but let's just stick to the jurisdictional issues here. So the case was argued in May of this year. And at the argument of the case, we told the appellate court, hey, look, there's a case at the U.S. Supreme Court that might be dispositive about this. And at that argument, the plaintiff's counsel conceded that if the U.S. Supreme Court ruled in favor of BMS, then they lose. And that was a flat-out concession on the record. So, the case is argued in May. The BMS decision comes out in June. It's 5 months we're sitting waiting for this decision. 5 months. And if you read the decision is 6 pages long, double-spaced. Right? And it's 2 pages, but there's a concurrence that's 2 pages long. So a total of 8 pages, and basically they decided that, hey, you know what? An out-of-court plaintiff, an out-of-state plaintiff, someone not from Missouri, shouldn't be suing someone from New Jersey in a Missouri state court, which is exactly the way BMS ruled. But why did it take that long for the court to rule? So that's my spin on this. The reason it took that long is exactly as we were talking before. These plaintiffs are fighting tooth and nail to keep these magical jurisdictions alive. So this is a case that we tried to a verdict. We raised the issue of personal jurisdiction from day one, from the date that the complaint was filed. We argued over and over again at the lower court why there's no personal jurisdiction. All they argued back was pendant party jurisdiction. Daimler had already been decided at this time. What was the hang-up? Well, the plaintiffs came into the Missouri Court of Appeals and said, hey, we may have other evidence to show that there's some connection with the state of Missouri. This is after a trial is done. And the court sat on the decision for 5 months thinking about this. And frankly, I think they were thinking that maybe something might happen in the lower court, which right now we're still in the middle of dealing with. So, what does this mean from a corporate perspective? I think we understand that plaintiffs like to be where they are. There's a reason why there are these jurisdictions, and the jurisdictions we see basically are, St. Louis, California, Philadelphia, and it used to be Atlantic City. Still may come back to Atlantic City at some point. Judge Johnson is going to retire soon right here. So who knows what's going to happen. But there's a reason why these plaintiffs go to these magic jurisdictions, and they really, really like being there. They're not going to give up. So the other thing that it means for us is looking for these connections. So we agreed that it would be great if the Supreme Court could come down on some standard about connection related to or arising from. So right now, these plaintiffs are searching for things like, we have some cases where they find, cases pending in Philadelphia that have been pending for like 6 years now. And so we've tried several cases already, so we have a full discovery record. All of a sudden, when faced with this jurisdictional issue, the plaintiffs now point to a low-level employee that lived in Pennsylvania, whose name has never come up in the 6 years that we've been litigating this. And she is now considered the mastermind of the strategy, right? So they're looking for things like that. In St. Louis, they're looking at contract manufacturing. Did anybody with any component part, happen to have any connection with Missouri? Now again, we think the McKesson issue takes care of that, but they are searching and digging. So what does that mean from a corporate standpoint? From a corporate standpoint, look, it's hard to change your place of incorporation or your place of business. So principal place of business, that means moving everything out of a state. For the state of incorporation, we're fine. So not that we haven't thought about this. It's hard when you're a drug manufacturer to change your state of incorporation because all your licenses have to be changed from DEA for manufacturing purposes. So there's a lot of hurdles to that. But if plaintiffs are going to rely on contract manufacturing, those types of connections, well, there are contract manufacturers everywhere. So we can, if there is a contract manufacturer in a bad jurisdiction, then I'm sorry, those jobs are gone. And they're going to move to a state where we don't have such a problem.
Do you mean that literally, like you think there are corporations, perhaps J&J, are going to send out a corporate directive, do not sign a contract with anybody in the state of Missouri?
Yes. So step one was stop looking for stop registering businesses in states. And I'm sure there are companies that have lists of states where you will not find a registration to do business.
Well, J&J is in New Jersey, but I'm sure there are other companies that have New Jersey on them.
Yes.
Right.
So it's clearly, if this is the way jurisdictional fights are going to go, then there are ways to reduce your footprint in bad jurisdictions. So again, we used to always talk about, we're going to change a place of business. We understand that's very hard. But contract manufacturing, where you get suppliers, things like that. That is fairly easy to change, and people are willing to move. So that's sort of a practical issue. The other practical issue that we see is, there is going to be a movement, I think, for more MDLs. Now, MDLs have always been popular, but I think you're going to see more of that happening. In order to try to avoid MDLs, there's a lot of plaintiffs who are naming non-diverse co-defendants. Co-defendants that get rid of complete diversity. That's another issue that we're looking at on how to deal with that, either from a purchasing, or supply, how we deal with these companies in the first place, or can we change the law so, there should be innocent seller statutes. So for example, when we get sued along with the local, all they did was sell the product, the local Walmart, there's no real cause of action against the Walmart. There's really none. But courts are reluctant, the federal courts, frankly, are reluctant to throw those cases back on fraudulent joinder theories. And so, that's, some issues that we have to look at. So innocent settler statutes, fraudulent joinder, consolidation, and coordination legislation. So, there are states that have, like New Jersey, consolidated proceedings. Is that a good thing? Is that a bad thing? Is it going to encourage for our New Jersey companies? Are the mass courts going to move to New Jersey because it's easy to put them all in one place? And the reason that's important from our perspective is that, as Chris was alluding to, there is a business model that we see plaintiffs using. And the business model is based on aggregation of claims, mostly aggregation of frivolous claims. So the way that we see the business model going is you do a ton of advertising, you get as many people signed up as possible, you find a favorable jurisdiction either for an NPL or for a state consolidated proceeding, and then you hide 99% of the cases that have no merit, and you bring up 3 or 4 cases that you think might have some jury appeal, bring those to trial, and then try to coerce a massive settlement where you get everything paid off. So, so we see these consolidated coordination of regulations as helping feed that process. We also see bellwether trials as helping to feed that process.
Well, let's talk about the economics of this. Imagine a universe in the distant future where the law is uniform. We don't have competing among various states. We're not looking for that New Jersey or that Missouri. Let's assume the law is going to be the same to all states. And let's forget about the fact that it's not just the law that's different. There are cultures that are different. But let's put that aside too. Let's assume we have 50 states that are equal. Does the corporate entity in America really want to try 50 separate cases? Or would you then be okay with one lawsuit and get it all resolved at one time?
So you're talking about, so I'll play like an expert witness on this scam. You're putting these assumptions in that I just really can't put my head around. The fact is, look, if you're in a perfect world where you knew that in one case you were going to get the right result, then economically it's absolutely true that it makes no sense to try to split those off. But that's not the world we're living in, right? And so again, if the world is such that if you can stop the plaintiff from aggregating frivolous claims with in one jurisdiction, then to break that business model makes much more sense. So it's not that we want to try 50 cases or 100 cases, and it's not that we think that we can outlast the plaintiffs in a war of attrition. What we do believe is that the closer we came to your perfect system, then what plaintiffs would do is stop bringing frivolous claims to aggregate, right? So it's not only would we want to try 50 claims versus one claim. It's if you have that perfect system, would plaintiffs stop bringing frivolous claims in bad jurisdictions? You'd be left with one-off claims that might be meritorious. And that's all I have to say.
All right, Ted, it's up to you.
Thank you. Thank you for having me here and for setting this up, Alita. I'm sort of on a different panel. We just got me here. We have all these smart litigators talking about the nitty-gritty of all the issues that BMS opens up and how they're dealing with it. And I'm here to sort of talk about the political, the public choice and political theory of state court tort reform and how Bristol-Myers Squibb decision might affect that, and why there's been this difficulty in getting reform, and where BMS might be able to break up the logjam and get that sort of 30,000-foot view. And by 30,000 foot view, I mean I'm actually going to start by talking about Federalist number 80, where Hamilton talked about the need for diversity jurisdiction because of the fear that in a large national state, in a large nation, you would have state courts that would discriminate against out-of-state defendants. And by setting up diversity jurisdiction in a federal court system, you could have the promise of interstate commerce and defendants being treated fairly as they do business across state lines. And we had that set up at the beginning of the nation's history and on through the middle of the 20th century, where you could either sue a defendant in the defendant's home state and get the defendant's state courts and the defendant's state law, or you could sue the defendant in your own home state, and if the defendant didn't like the way your home state was treating out-of-state court defendants, they could remove it to federal court, and in federal court they would get a federal judge who was supposed to be considering the national implications, and most importantly, a federal common law. That was just a baseline default. And then in 1938, Justice Brandeis, in his infinite wisdom, decided Erie Railroad versus Tompkins and abolished federal common law, and now federal courts are adopting the state law that they're in terms of the incentives of state lawmakers. Before, there was no incentive to sort of slant the system because slanting the system just hurt your own in-state defendants, but couldn't help the in-state plaintiffs because if your law was too slanted, the defendant would just remove it to federal court and get the federal common law, and now that was no longer true. And once that happened, now every state has an incentive because you have your in-state plaintiffs and you have your out-of-state defendants, and absolutely no reason not to move the law to favor the in-state plaintiffs over the out-of-state defendants and try to extract the gains of interstate commerce through the court system, and have wealth transfers from the out-of-state defendants to the in-state plaintiffs. And my favorite example of this is the state of Nevada. If you're a pharmaceutical company, you're absolutely familiar with the Desert Shadow Oncology litigation, not oncology, endoscopy. The Desert Shadow Endoscopy Center and the litigation there. And what happened at Desert Shadow is you had a doctor who ran these endoscopy centers and then had a very creative business model whereby he reduced costs by reusing needles. And that had implications in that dozens and dozens of people ended up with hepatitis C. And they sued and they bankrupted him, and he went to jail for basically criminal malpractice. So now the plaintiffs start looking for a deep pocket, and the deep pocket was the manufacturer of the generic propofol that was being injected in these proceedings. And the theory of the case was, well, you should have warned him not to be breaking the law and using needles and things like that. And you would think that, the interceding cause of the criminal would make a difference. But the defendant was not allowed to introduce evidence that the nurses were being told to ignore warnings. And sure enough, when you have a sympathetic plaintiff and a one-sided presentation of the evidence, the out-of-state defendant was getting hit with really gigantic verdicts for causing all this hepatitis C. And eventually, Teva Pharmaceuticals settled these cases for hundreds of millions of dollars. And that's a very clear example of the plaintiff-friendliness of Nevada state courts when they had that opportunity. But it's interesting because there's, at the same time that Nevada courts are almost uniformly plaintiff-friendly, there's this class of cases where suddenly the solicitousness to the plaintiffs disappears. And that's the area of casino litigation, where you have all these in-state defendants and all these out-of-state plaintiffs who are visiting casinos and might want to sue them for one reason or another. And it's pretty well known that the casino always sorts of wins these cases. And so there's no let's do things for the plaintiffs in Nevada, it's let's do things for the Nevada residents at the expense of the other 49 states. And that has implications for tort reform. Michigan passed a very pharmaceutical-friendly law creating preemption in a variety of product liability cases where the FDA approves a drug and barring really remarkable fraud, that precludes any sort of product liability cause of action for injuries supposedly caused by the pharmaceutical. And if you look at the effect of that, what are the the Michigan lawmakers doing by passing that law? Well, it's very kind of them to benefit the out-of-state defendants, but it's not like the pharmaceuticals are now going to give Michigan consumers a lower price on their drugs to reflect the fact that they're not going to be hit with frivolous suits. So all of those cost savings to the defendants accrue to the out-of-state defendants and to the other 49 states, with Michigan consumers capturing 2% of the benefit, but incurring all the costs in that they don't get to have the favorable plaintiff causes of action that other states might have against a pharmaceutical company. And that is a very politically difficult thing for lawmakers to do, and it's really surprising that Michigan hasn't yet repealed it, but it's also not so surprising that the other 49 states haven't joined in this collective action problem and made the law a better place to protect business from abusive lawsuits. And so where does Bristol-Myers Squibb come in? And unfortunately, the short answer to that is, well, it's a little too soon to tell, as John and John indicate. The plaintiffs are trying to get around the scarier implications to try to keep the jurisdictions where they've won really successfully and look for holes in what EMS does. So there's still several years of litigation for that to shake out. But if we assume that Sean wins all these cases and gets a sensible rule where you can't drag defendants into court, it's where they don't really have proximate causation and so forth. It has really strong implications of changing the dynamic of asking for state legislatures to do things to improve the civil justice system. Because now, when you're deciding where to locate your headquarters, probably not going to change for Bayer anytime soon since they just built this, but for anybody else, now it sort of makes a big difference. It's nice that a state might provide you a $200 million tax break, but if their court system is going to cost you $1 billion in the long run because you can get sued there and they don't have Daubert, maybe you consider locating in a more favorable litigation jurisdiction. And sure, the location decision can't just ride on the tort system. You got to look at the education and the real estate prices and all of the other things that you look at in a location decision. But whereas before Bristol-Myers Squibb, where it didn't really matter where you located because you were going to get sued in St. Louis County anyway, if Bristol-Myers Squibb shakes out the way it should, now it really does make a difference where you're headquartering, or even if the plaintiffs win on the contract manufacturing issue, notwithstanding McKesson, as John suggested, you can start pulling the contract manufacturing out of the bad states, and that will also provide incentive for legislators to sort of favor the social good over the interests of the litigation lobby. And this is more than a little hypothetical. Recently, Foxconn was deciding where to locate a factory, and they decided to locate in Wisconsin. In addition to the standard package of tax breaks and infrastructure improvements, one of the concessions that they won was actually a law to be passed by the legislature suggesting that when it came time to build the factory and the environmentalists in the local community sued to delay the construction and so on and so forth, there would be an expedited procedure where this could be immediately appealed to Wisconsin's Supreme Court, and whatever that litigation result was, it would get resolved quickly. And in return for that, Foxconn would agree to build their factory there. So it is possible to sort of to get these sorts of concessions to improve the civil justice system as part of your locational decisions, and that should start to come into the calculus, and that might change the public choice dynamic where state legislatures have absolutely no incentive to do things on behalf of defendants as they decide where the balance should lie in the civil justice system, and I think that's very promising in the long run. And happy to answer questions about that.
Well, before we go to our last speaker, let me ask you a question, Ted. Where does efficiency play into this? I mean, John talked about a scenario where they had only a couple of Missouri residents. What if you have the reverse scenario? What if Bristol-Myers was sued in California by 1,000 California plaintiffs and 2 from Nevada? Do we really want to take the position that the 2 from Nevada don't belong there because that is violating BMS's due process rights, that it's unfair to make BMS defend those 2 cases?
Why not? I mean, it's an at what point do you do that cutoff, right? Well, if it's okay to have 1,002, what about 903? Which is why it's always 63 or 98 or 72 in these outrageous joined suits. So I don't find an efficiency problem there. If you have 2 Nevada plaintiffs, there's no reason those Nevada plaintiffs shouldn't be suing in Bristol-Myers' home state. Or in
I'm a recovering plaintiff's lawyer. So, as was mentioned, I have had occasion to be on the plaintiff's side, including in a couple of class actions, but our firm, Spiro Harrison, is primarily corporate, represent corporate entities, and I think, frankly, if I may briefly expound on that, I think that in my experience, both as a former federal prosecutor who now does defense and as a former plaintiff's lawyer who now does defense, I think that the perspective of being able to evaluate a case is broadened by having been on both sides. I mean, it's not to disparage anybody who, like my former colleagues, who would never dream of leaving the U.S. Attorney's Office and going to a defense firm, and likewise colleagues in the defense bar who couldn't dream of being an evil prosecutor. I think there is a lot of room for nuance in evaluating the cases and evaluating different circumstances. So with that being said, I will don the hat of the plaintiff's bar for the purposes of this discussion. I think that this basically boils down to a couple of broad issues, which I think Ted ably, as always, articulated. One is, you have companies that are national and international. You've got Bristol-Myers Squibb. You've got Daimler. They are very happy to market their wares nationally and internationally and profit therefrom, and that's great. However, as you saw today in some of the comments of the panel, when a company goes into, say, California, and say it's Daimler, and if you know something about the car industry, California dictates to a large measure, although somewhat less than it used to, because China is on the ascendancy, how cars are designed and manufactured. California dictates things like mileage. California dictates safety. And that's because California just has more cars than anybody else. So it's efficient for companies to design cars for the California market. Likewise, California is a huge, needless to say, market for all sorts of products, but not the least being pharmaceuticals. McKesson is, I believe, the largest distributor of pharmaceuticals in the world. Multi-billion-dollar corporation. I think it's literally in the top 20 of Fortune 500, if not higher. Yet, when it comes to paying the piper for products that may be alleged to be defective, all of a sudden, California becomes, in John's terms, the magic jurisdiction, where undeserving and frivolous plaintiffs go with their lawyers to a friendly venue before friendly judges to get unjust rewards. And I think that the real push and pull here, putting aside the niceties and of the evolution of federal jurisdiction and the applicability of the due process clause to these questions, is simply that. Companies want the benefit, but without incurring the potential liability of doing business. And I think, again, to drill down into that a little bit, you have, again, the second major issue being a very basic dichotomy between, and you see this particularly in class action, but not necessarily, but in mass actions and so forth, where you have plaintiffs who are in different states, who are may not be injured in California, but are part of a mass action and join or file a lawsuit in California against a company that's not ostensibly in California. I hasten to add that there's a fair amount of question begging as to whether a company is, at home in a place like California where it does billions of dollars worth of business and has a huge market. That perhaps the extreme of that is just sort of Mayor's view, which is sort of this kind of borderless world that we're all, part of indeed, but not only the country but the world, so that plaintiffs who are foreigners can sue other foreigners for things that happen overseas in any court in the United States that they so choose. I mean, I think that the fact that she's a lone dissenter illustrates the validity and viability of that extreme extension of jurisdiction. But, here we are in the middle, trying to figure out what the appropriate push and pull is as far as a particular state. Again, going back to this basic dichotomy, you have states like California, and for better or for worse, we're still, a republic made up of states, and states have the ability under their police powers to have an interest, which is at least noddingly noted by the Supreme Court, in having their laws apply to people or companies that do business in their state. The consistency issue is also an important one, i.e. that query whether under Bristol-Myers you're going to have sort of a diaspora of cases sent to various jurisdictions to the basic undermining of consistency in result and consistency and really fairness. Who files first, where? Is that case that's filed in New Jersey going to dictate what happens when somebody files a year later on really the same claim in a different jurisdiction before a different judge? As Ted noted in the case in Nevada, you have a judge there who evidently disregarded the evidentiary rules of using that judge's discretion to allow evidence in, or to exclude, I should say, evidence of the criminality of that medical practice, and got the result there, but query whether that really is something that is a virtue of this, a result of this Nevada being a plaintiff-friendly state, or just a judge who was plaintiff-friendly and essentially excluded evidence that should have been included. But Ted's example goes directly to the point of consistency. And the reason that we have, class actions, mass actions, and the benefit of having a case brought in California, even if it includes non-California residents, is that it's going to be consistent. It may be, viewed as a magic jurisdiction, as John said, where the plaintiff wins, or as John also said, a place where you get the right result, which I guess means that the plaintiff loses. But it'll be consistent. I think I'm probably raising more questions than I'm answering here, but I just think that there are a lot of issues with regard to the really pragmatic aspects of and impacts that are going to result from sort of the high-minded discussions of the Supreme Court about the Due Process Clause and how it's being used to enforce Federalist principles. I mean, I quote from Bristol-Myers, and they're quoting in turn Worldwide Volkswagen. Even if the defendant would suffer minimal or no inconvenience from being forced to litigate before the tribunals of another state, even if the forum state has a strong interest in applying its law to the controversy, even if the forum state is the most convenient location for litigation, the Due Process Clause, acting as an instrument of interstate federalism, may sometimes act to divest the state of its power to render a valid judgment. Well, being a dyed-in-the-wool conservative, when I see the Due Process Clause trotted out, I generally think that it means that whatever majority of the court happens to think is the just result is the way that that's going to go. Here, you have the court basically poo-pooing extremely interests, including a state sovereignty, and the interests, as noted in of the state's strong interest in applying its law to a controversy, even if it's somebody who's not from the state, the defendant's ostensibly not from the state, but the defendant, again, take California, please, has a very powerful economic influence on not only the national commerce vis-a-vis this particular corporate defendant, but international commerce, even to the extent that it may dictate, as I said before, the product itself in many ways.
Well, if I can interrupt, let's talk about the federalism for a minute, because you and I talked about this, and I know you have some view along the lines of what you said, that a state has some interest. If we look at federalist principles, the state has an interest in policing and applying its police powers to its citizens. But isn't there a natural limit to that when we're talking about its impact, even the police power impact, and maybe especially police powers, on someone from out of state? I mean, if we put the civil situation aside and talk about actual police powers, I don't think there's any question that we would all be troubled to say that California has a right to bring a criminal case against me as an out-of-state citizen for out-of-state conduct that impacts the California citizen. The police power only reaches so far, even though California has a real federalist state powers interest in protecting the putative victim of my crime, and that victim lives in California. If I'm not in California and my offense did not occur in California, California's police powers do not reach me in a criminal context. Why should the civil situation be different?
Well, it's dependent upon what the offense is, and it's certainly to somewhat begging the question that the offense does not affect the state. what I'm talking about is our national and even international companies that market everywhere. They advertise everywhere. They sell everywhere.
So let's take Plavix, for example. BMS is selling Plavix all over the country. I buy it in New Jersey, or take it in New Jersey, I'm injured in New Jersey. Does California, because it's worried about Plavix's impact on the universe, does California have the right to drag me into California for a lawsuit?
Well, again, it depends on whether, I think we're talking about the joinder of you with other California plaintiffs.
Right.
I don't know if it would be strictly that California could somehow pluck you out or that you would go and file in California. I think that's obviously directly what Bristol-Myers is talking about.
Right, and that's part of what we were talking about before with John and Ted. Do we look at jurisdiction differently when I, as a plaintiff, have part of a larger group? Is it really a different analysis? Maybe it should be. I mean, Ted seemed uninterested in my efficiency question. I mean, should we view this differently if I'm the sole plaintiff and I want to sue BMS in California versus I'm one of 800 plaintiffs?
Well, I think to pursue the California interest, I would say that, again, from a plaintiff's point of view, yes, California could and would ostensibly have jurisdiction. Certainly Justice Sotomayor would say so in her sort of borderless view.
And perhaps part of the reason the answer to that is yes is because it's hard to conceive of this being unfair to Bristol-Myers, right? Due process at its heart, when it at least was conceived as the buffer to jurisdiction, it was about fairness to that defendant. It can be hard to see an unfairness to Bristol-Myers when it's defending. When you're defending 200 of these cases from California defendants, is it unfair to defend my case as well? Is it unfair?
Well, yeah, there's a couple parts to that.
Go for it.
When you're talking about efficiency, well, why are you bringing California in the first place? Go to Bristol-Myers' home state, and you can be as efficient as you want.
What about unfairness, though? Is it unfair to Bristol-Myers?
Absolutely, because you're permitting a sort of forum shopping.
That's exactly right. And forum shopping is one way, right? Okay, defendants don't get to choose what forum they're in, and that's something that is solely within, the choice of the plaintiff. And so to give the plaintiff unfettered choice, to find the worst jurisdiction they can find to bring you there with the purpose. Look, I used to have a lawyer that said, I want to get every fair advantage that I can get, which is fine. But it's, when you start doing this, when the system allows you to bring these cases in the worst jurisdiction you can find, solely for the purpose of bringing it in the worst jurisdiction, that seems a little unfair to me.
Yeah, so actually having done sort of behind the scenes on Bristol-Myers, we thought about this a lot because we knew we were going to get, and I'm revealing no secrets, I think Neil told us to the National Law Drama. We knew we were going to get the question, what is the unfairness to Bristol-Myers? Why does Bristol-Myers care? They're a big company, they have attorneys everywhere. And the answer was a couple-fold. Number one is just sort of to reject the premise that this is about fairness. And one interesting thing about the court is that it swung back and forth. Is personal jurisdiction about federalism or is it about fairness? And the answer is kind of both. Because obviously it's not jurisdictional in the sense that you can waive it and you can consent to jurisdiction like real consent like in your contracts. But it's also about the relationship of the states with each other. And one of the questions that Justice Kennedy asked at oral argument that I thought was pretty interesting was he said, look, isn't it kind of, if you have the plaintiff from Ohio where he took the drug and he was injured there, isn't it kind of paternalistic for California to step in and say, don't worry, Ohio, we got this. You don't have to worry your pretty little head with resolving torts, even though you might care a lot about, your citizens, that, we're just going to be the mass tort capital of the nation. So I think that's the first one, is to say, is it really about fairness? And I think we've seen the court swing back in Bristol-Myers Squibb to at least say that there's a strong federalism component to it. And the second part is, it's actually more burdensome and unfair than you would think, particularly in mass pharmaceutical torts, because, as I think everybody knows, the key issue in a lot of these cases is causation. And causation is, particularly at specific causation, you have to go to depose this person's doctor. And the California courts can't subpoena this person. So either you have to really hope they're going to cooperate, and you're going to have to schlep all yourself out to where this doctor is and take their deposition. And it's going to have to be a videotaped deposition that isn't going to have the same effectiveness at trial that a live witness would. And there's a lot of concerns about that sort of, you'd like to think that these are 2,000 identical claims, they're not. And so there is actually a fair bit of unfairness that if you had just broken down the cases and sent them to the individual states, you wouldn't have. Now, maybe you could respond that, well, wouldn't you have the same problems if they all filed in New Jersey? Well, they indisputably could. But then, there is an unfairness. And I think the final part I'd say is, plaintiffs only care about the forum shopping aspects of it because that's the plaintiff's sort of only concern when they go file their lawsuit. But defendants don't solely choose their home state based on litigation concerns. I think Justice Kagan posed the question, isn't this just forum shopping on both sides? Plaintiffs want to have their favorite forum, defendants want to have their favorite forum. And the answer we couldn't give, and we thought about giving, was, Justice Kagan, have you seen the New Jersey courts? A bunch of pharmaceutical companies aren't here because they have thought that the New Jersey courts are a mecca for tort defendants. They chose it because it's a great location, they have an educated populace, and historical reasons. But companies have a much more sophisticated choice of their forum, so it is a very one-sided battle.
Well, I would postulate that the pharmaceutical companies like New Jersey because of CJI, but that's just my personal.
Good.
That one?
Amazon is not coming.
So I want to touch on something John was just talking about how defendants don't get to choose their forum. One of the things that the majority says in BMS is we're supposed to take into account the plaintiff's choice of forum. Is that lip service? Can that really happen in the framework that the court is setting up here under both Daimler and BMS? Does plaintiff's choice matter? Where does that fit in the framework? I don't see how that plays into this analysis. Under Daimler, here's how we're going to describe the paradigm general jurisdiction. Under BMS, here's, well, at least as Sean said, BMS is really about what's not specific jurisdiction.
Yeah.
Where does plaintiff's choice enter into the analysis?
Well, nothing about even the most narrow view of, or the broadest view of Bristol-Myers Squibb limits plaintiff's choice of forum to one forum. They can sue at the place of injury where there's going to be specific proximate cause jurisdiction. They can sue at the defendant's general jurisdiction, and there'll be one or two or more places where that can happen. And even within those, there's often venue rules from state to state. So you don't like the judges in Los Angeles County, go to Alameda County, and assume the venue rules permit this. And different states have different venue rules in that regard. Once upon a time, Pennsylvania allowed anybody to go to Philadelphia.
Do you think that the court's historical discussion about giving some deference to the plaintiff's choice of forum, do you think that's what they were talking about? I have trouble believing that.
I mean, I think it is true to say that, if there are several forums that are possible, defendant doesn't get to choose among them, at least as a constitutional matter. There might be forum non-convenience under state law, there might be venue rules, but, to take Bristol-Myers Squibb, I think we pretty much agreed that jurisdiction would be proper in Delaware, where they were incorporated, in New York, where they're headquartered, and probably New Jersey, where a lot of the relevant decisions were made, because there's a large campus here. And if you pick one of those three, we don't have a personal jurisdiction defense, and we might like one of those three more, or we might like the plaintiff's home state more, but plaintiff gets to pick in that regard.
But what you mean by choosing then, and giving some deference to the plaintiff's choice, you're saying the plaintiff can choose among the few states that are left available to the plaintiff. I'm playing devil's advocate here. The plaintiff's choices are basically limited to where has injury occurred, if there's a sufficient tie to the injury, principal place of business, and state of incorporation. Those are the three choices. It's not a lot of choice.
But the due process clause among them doesn't have anything to say about among the three, which I think is probably
my thinking is I think this notion that the Bristol-Myers majority is referring to, I personally think it's lip service. I don't think the plaintiff's choice means anything anymore.
May I just,
No, I think all of this is, the discussion is good, and it's how decisions are often made, but it's rather, I guess, philosophical or something. And I don't know that the plaintiffs in these cases have any choice of anything. They pick up the phone, call an 800 number, and get sent where, I'm not joking,
No,
and
sure.
get sent wherever the mass action plaintiff lawyer decides is the best place for him to try his case. And that comes back to the issue of discussing fundamental fairness and California's comedy or whatever, the right word, how they care about what happens in California and the economic flow and all that jazz. That has nothing to do with all the cases being filed in California either. It's the mass action plaintiff lawyer who decides, I want to bring these cases in California. And it's not, I get the point of the scenario you're raising about efficiency, but it's not 200 California plaintiffs and 2 Missouri or 2 Alabama plaintiffs. It's 2 California plaintiffs and 76 plaintiffs from all over the country. And then it's another complaint that's filed just under the 99 threshold. And so now you have six complaints with 12 California plaintiffs and hundreds of out-of-state plaintiffs. And so it's all just a big game. And the legal kind of philosophy is very important because it applies to more than just product liability mass actions. But the way that I see it from this side is it's just a game that's being played to drive the model of getting mass actions and all of the ease with which it becomes litigating and getting settlements through mass actions through, 40% of those cases not even having any merit. So when you talk about efficiency, what is efficient about driving massive actions where nobody has any merit? Where if you had to try your own case, you wouldn't ever bring the case. Now people on the other side of the view will say, well, it opens the door to people who have merit-full cases who otherwise wouldn't be able to get into court, blah, 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 blah. Lawyers presented with a merit-full case in a one-off, if they had to do it in a one-off situation, would still bring their case because look at the verdicts that are being rendered here. So the idea that I'm walking to my lawyer in Wisconsin and he's going to turn me down if I was really injured by this drug is fake. Because if you were really injured by that drug in whatever state you're in, you'd be like, heck yeah, now I don't have to share my profits with the PSC or anything. I just get a $100 million verdict. And so, it's an important discussion to have, and it's because it's going to drive what the Supreme Court does, it's going to drive what real courts do. But I think on the ground, it's a lot different than what it is in opinions and textbooks.
And before I hand it to Ted, who has much more salient things to say than I, but I will attest to what you're saying. Candidly, I found when I was at a firm that did a case where there was sort of like a burgeoning people starting to file cases in an automotive context, and I located potential plaintiffs and wanted to actually sit down and meet with them, and was directed like, "What are you talking about? Just send them a complaint and file it. What are you wasting your time with that?" But Ted, I assume you want.
Yeah, certainly what plaintiff's attorney Mark Lanier called the chicken catching and chicken plucking aspect of mass tort litigation is a scandal that's yet to be fully uncovered, and presumably defense attorneys will do that sometime in the next 10, 15 years, and maybe that will cause some reform. But going to Shalom's point, with respect to the plaintiff's choice of forum, it can't be entirely unfettered. It can't be that they get to go to Madison County, Illinois, no matter what. Either when you give the lip service to plaintiff's choice of forum, it's always within the constrained rights of where you can bring the case. And there's always going to be multiple options to bring the case. And if you're going to complain about the plaintiff's choice of forum being disregarded, the MDL process that sweeps plaintiffs in if they get into federal court and sends them somewhere in the country that they might not have any say over, and then takes away part of the control of the case and hands it over to a PSC that's selected through some probably really scandalous horse trading. as the efficiency versus plaintiff's choice of form goes, I think that's a much bigger concern than anything Bristol-Myers is doing.
But even in that context, they're entitled to go back to their original form for trial. So,
Which
yes,
never happens.
Which never happens, but that's not because they don't have the option of doing it, it's because they never really had a claim in the first place.
Can I ask a question?
Yep, go ahead.
And we do invite questions, I just want to have one of my own for the Bristol-Myers lawyer, and I suppose this is more of a defense-oriented question, but, we talk about Bristol-Myers, and it seems to be undisputed that New Jersey would be an appropriate venue. Why is that the case? New York is the headquarters of Bristol-Myers. New Jersey, I guess what sticks in my mind is, okay, New Jersey, decisions were made about the product. The marketing, I guess, was designed in New Jersey. But how is that different from having McKesson, distribute in California?
Sure. So number one, it's that the claims in the case were essentially the usual things you'd expect: negligent design, negligent marketing. The decisions regarding those things, so the alleged tort that occurred, to the extent it occurred anywhere, it did. We were willing to concede, and what the evidence showed in that case, it was made because the people made the decisions in New Jersey about how are they going to market these things, how are we going to design these things, how are we going to manufacture these things. The way it distinguishes McKesson is, and I think, and this maybe goes back to John's discussion about what does the McKesson part of the Bristol-Myers Squibb decision say. At most, at the least it says the mere fact that you have an agreement with McKesson, who is a distributor in some general sense, is not enough, because that's like saying, well, Ford sells cars through car dealerships, you bought your car through a car dealership, the folks over in California, I guess, are also a car dealership. Because remember, none of these plaintiffs could actually show that their drugs came from McKesson. They just joined McKesson because McKesson's a large distributor and happens to be headquartered in California, and thus could defeat removal, which they tried. And I think that gets back to the fraudulent joiner fight we were talking about earlier. So it's not so much that the distributor couldn't be the link, particularly if you were a plaintiff in the state, because remember, drug companies don't sell drugs to patients. They sell them to distributors who sell them to pharmacies who ultimately sell them to the patients. So we're sort of willing to acknowledge that if you buy your drug in the state, that might be enough. But the mere fact that a distributor in the large or the writ large sense exists in the state without any link to those particular claims, that's what Bristol-Myers talks about.
I'm going to just see if anyone in the audience wants to ask a question while I hand the mic this way. John?
So it's also a decision between general jurisdiction and specific
Right,
jurisdiction.
yes.
And so that was the international sheet, frankly, as to why, it doesn't apply, so.
Well, let me throw a question. Oh,
I just have a
Chris.
question about the jurisdictional discovery issue. What, is there gonna be a court where you can just say, and they'll find an defendant's there? We don't need jurisdictional discovery on this, because even if we're doing what the plaintiff is saying we're doing, that's not enough to get us to that position.
Yeah, so of course it's going to depend on sort of the individual discovery rules in each state. This is vastly overgeneralizing because New York barely requires anything to get to jurisdictional discovery. Many federal courts will allow you to say, we don't have to do jurisdictional discovery because I'll take all your pleaded facts as true and it still doesn't add up to jurisdiction. Some courts say that if you sort of make a prima facie showing or like you have a good working theory for what you think you might find, you can get to jurisdictional discovery. So oftentimes what we do is, we'll argue, look, I'll take every fact in your complaint as true, no personal jurisdiction, why should we have jurisdiction? But a lot of courts would say, well, if they have a good theory about what they think discovery will find in good faith, we'll let them do a little bit. We had started out sort of saying no discovery ever, what are you talking about? That did not go well at courts because they're saying, well, can't you give them something? Oftentimes what happens is, if you'll answer a little bit, interpose objections to the rest, plaintiffs aren't going to do the compelling answers because they don't know what they're going to do with it. I mean, oftentimes they'll serve jurisdictional discovery on you, thinking it'll just be really burdensome and you'll withdraw your motion. And if you call their bluff and say, here's some stuff, we'll object to the overbroad stuff, now what do you want? they'll kind of not really have an answer for how they're going to use the things you gave them. So we've had some success with that kind of past where you give them the things that are easy to give, you object to the rest, and then essentially dare them to file a motion to compel.
From a practical perspective though, from a practical perspective, remember where you're making these motions. You're making the motions in these magic jurisdictions that you're trying to get out of anyway. So we've had very limited success trying to get rid of jurisdictional discovery. We have had some success in the federal courts when we remove a case and the plaintiffs say we need jurisdictional discovery to see whether it should be remanded back because of, we say this fraudulent joint or personal jurisdiction, it's got to be. But in those cases, we're about 50-50 on federal courts, whether they'll remand it for jurisdictional discovery or just decide that jurisdictional discovery is not going to be done and we're keeping the case.
Sir?
This might be more of a public policy question or corporate governance question, but Ted, you had talked earlier about Foxconn getting a law changed in Wisconsin before they were going to build a plant there, and we talked about corporations minimizing their points of contact with certain magic jurisdictions. So I'm wondering about your perspective on what is the responsibility of corporations to take those actions, maybe responsibility of their shareholders to take actions to minimize contacts and minimize litigation like we're talking about. Or maybe get laws changed through groups like NJCJ.
Well, absolutely, every corporation has a duty to be giving to NJCJ. I mean, a lot of that, in terms of corporate governance, well, that's always going to come down to the business judgment role, and if the CEO wants to headquarter his company in Madison County, Illinois, it's probably a dumb decision, but that's going to be up to the board of directors to punish him rather than for shareholders to say that they're breaching some sort of fiduciary duty. But I do think corporations need to be considering more of this, and certainly now that I talked about the Michigan change of law, and that there was really nothing you could do about that. Oh, we have this great Michigan law, but I relocate my factory in the Michigan suburbs. The plaintiffs still aren't going to be bringing their cases there. They're going to be bringing their cases anywhere. And in fact, even with the Michigan law, when all of these drug MDLs settled, and they set up a giant grid of who gets what, and an 8-dimensional grid of what factors, how long you've been taking the drug, and what injuries you supposedly had, and what your doctor said. None of that said, oh, and if you're from Michigan, you get 0. Like the Michigan plaintiffs got the same thing as everybody else, which I find interesting on multiple levels of ethics. But my view is that corporations aren't considering this enough. But that might have been rational because, as everybody else has mentioned, and as I mentioned, it's not just litigation that you're looking at when you're deciding where to build your headquarters, where to build your factory. But I think as these things start to grow into the billions of dollars in terms of product liability, you should be looking ahead at that sort of thing, and lawyers should be speaking up about it. And Bristol-Myers gives more and more reason for that.